Ever wonder what the differences are between a revocable living trust and a will? This episode of Estate Planning Essentials will examine the two options and point out the pros and cons of each planning strategy. Hey everyone! Welcome to Estate Planning Essentials. I'm Heather, Vice President and Editor-in-Chief at WealthCounsel. On this channel, we supply tips and information on document drafting and estate planning. So if you're a newcomer, please consider subscribing to the channel. And hey, at any point during the video, check out our show notes and links in the description below. Today, we'll be covering revocable living trusts. We'll discuss the difference between a will and a trust, what a revocable living trust is, and what a revocable living trust should be accompanied by. So let's get started. In a comprehensive estate plan, either a will or revocable living trust will serve as the foundational document. One of the most common questions presented by a potential client is, what is the difference between a will and a trust? In simplest terms, a will disposes of your assets at death, whereas a revocable living trust, also known as an RLT, is created during one's lifetime and assists in the management of assets both during times of incapacity and after your death. While wills are often initially cheaper to set up, wills have several disadvantages in the long term. Wills require probate upon the death of a testator. What is probate? Probate is a court-supervised process to distribute the assets of the decedent. It's public, lengthy, and potentially costly. Probate takes time, often a minimum of 6 months, but in some cases, probate can last for more than a year. Probate costs money that would otherwise be able to be passed on to beneficiaries. Revocable living trusts are often the better alternative. RLTs are set up during one's lifetime and immediately go into effect once the trust agreement is signed. A person establishing a trust is referred to as the grantor or settlor. The trust itself is a legal entity, though it doesn't require its own tax identification number until a grantor dies. The grantor must put his or her assets into the trust. This is called funding. The trust agreement itself serves as a set of instructions on how the trust's assets will be managed during one's lifetime, usually by the grantor serving as the initial trustee. A successor trustee is nominated in the trust agreement by the grantor. The trust agreement also sets forth instructions on how a trust will be managed by the successor trustee during the grantor's incapacity, usually for the benefit of the grantor, as well as the grantor's spouse and dependents, if any. Upon the grantor's death, the successor trustee follows the trust agreement and distributes the grantor's trust assets to his or her intended beneficiaries. If a trust is properly funded, meaning that all assets that were owned by the grantor are either properly retitled in the name of the trust or payable to the trust upon the grantor's death, probate can be avoided. An RLT-based estate plan should always be accompanied by a pour-over will that allows for non-trust-owned assets to flow into the RLT after the grantor's death. RLTs may take longer to set up, are often more expensive, and require proper funding to work. However, RLTs are superior to wills in a few ways. Trusts provide a management vehicle for a person's assets while they're living, and importantly, can avoid the often adversarial court process of having a guardian or conservator appointed by a court if a grantor becomes incapacitated. Thanks for checking out this video, and please make sure to like and subscribe to see more videos like it. If you would like more information about revocable living trusts, you can always access that right here, or check out the links in the description below. See you next time!